Hello everyone, welcome to Learn Law with AKP. In today's class, we will study subject matter of contract of sale under sections 6, 7 and 8 of the Sale of Goods Act 1930. In the previous class, we learned how a contract of sale is formed. Now, an important question arises: what goods can actually become the subject matter of a contract of sale? Can we sell goods that already exist? Can we sell goods that will be produced in the future? Can we sell goods whose existence depends on a future event? The Sale of Goods Act answers all these questions. Let us begin. The subject matter of a contract of sale means the goods which are being sold. Without goods, there can be no contract of sale. The goods become the foundation of the entire transaction. These goods must generally be movable property and capable of ownership transfer. For example, a car, laptop, mobile phone, furniture, machinery, and books are all examples of goods. Now, the Sale of Goods Act classifies goods into three major categories. First one, existing goods. Second, future goods. Third, contingent goods. Understanding these three classifications is extremely important because examination questions frequently ask students to differentiate among them. Let us understand each type one by one. Existing goods are goods that already exist at the time when the contract is made. The seller either owns them or possesses them. For example, Ram owns a motorcycle today and agrees to sell it to Shyam tomorrow. Since the motorcycle already exists, it is existing goods. Most everyday sale transactions involve existing goods. Existing goods are further divided into three categories: specific goods, ascertained goods, unascertained goods. These classifications are important because ownership and risk often depend upon them. Let us understand each one separately. Specific goods are goods identified and agreed upon at the time the contract is made. For example, Ram agrees to sell his red Hyundai car bearing registration number AP01AB1234. The exact car is identified. Therefore, it is specific goods. Specific goods are individually recognized and separated from all other goods. Now, ascertained goods are goods identified after the contract is formed. Unascertained goods are not specifically identified at the time of contract. For example, a shopkeeper agrees to sell 50 bags from a stock of 500 bags. A shopkeeper agrees to sell 50 bags from a stock of 500 bags. The exact 50 bags are not identified. These are uncertain goods. The exact 50 bags are not identified from the stock of 500 bags. So, these are unascertained goods. Once the 50 bags are selected and separated, they become ascertained goods. Now, future goods are goods that do not exist at the time of the contract. They will either be manufactured, produced, or acquired by the seller in the future. For example, a farmer agrees to sell next year's wheat crop. The crop does not yet exist. Therefore, it is future goods. A contract involving future goods generally becomes an agreement to sell. Contingent goods are special type of future goods. Their existence depends upon the happening of a future uncertain event. For example, Ram agrees to sell a shipment of goods expected to arrive from another country. The shipment may arrive or may not arrive. The goods therefore become contingent goods. Their existence depends upon an uncertain future event. Now, section 7 and 8 deal with perishing of goods. Sometimes goods are destroyed before the contract is made. Sometimes goods perish after the agreement but before ownership passes. The law provides special rules for such situations. These sections protect both buyers and sellers from unfair consequences. Now, section 7 states Section 7 states that if specific goods have already perished without the knowledge of the seller before the contract is made, the contract becomes void. For example, Ram agrees to sell a horse. Unknown to both parties, the horse has already died before the agreement. Since the subject matter no longer exists, the contract is void. Now, section 8 deals with destruction after the agreement to sell. For example, Ram agrees to sell his car next month. Before ownership transfers, the car is completely destroyed in an accident without fault of either party. The agreement becomes void because the goods no longer exist. Thus, ownership can never pass. In the famous of Couturier versus Hastie, a cargo of corn was sold while both parties believed it existed. Unknown to them, the corn has already been sold elsewhere because it had deteriorated during transportation. The subject matter effectively no longer existed. The court held that the contract was void because there was no existing subject matter to sell. Here the principle established a valid contract requires the existence of the subject matter. If the goods do not exist, the contract cannot survive. Now, let us quickly revise. Goods may be existing, future, or contingent. Existing goods may be specific, ascertained, or unascertained. Future goods will come into existence later. Contingent goods depend upon uncertain future events. Sections 7 and 8 deal with destruction of goods. Let us conclude today's topic. The subject matter of a contract of sale consists of goods. These goods may be existing goods, future goods, or contingent goods. We also studied the legal consequences when goods perish before or after the contract. Finally, we understood the important case of Couturier versus Hastie. Therefore, understanding the subject matter is essential for studying the Sale of Goods Act. For examinations, always remember classifications of goods, sections 7 and 8, examples and case law. Thank you for watching. If you found this video helpful, please like, share and subscribe to Learn Law with AKP. See you in the next class.